Because the United States Supreme Court has said we have to analyze Second Amendment cases involving text and then, in particular, history, it's very important that you understand the history that needs to be reviewed. And make sure you don't step on any legal landmines. That's why we're going to get super geeky here, and I'm warning you, you're going to have to think through this episode, but it's going to be worth it in the end. I'm going to make you the smartest person in the room when it comes to your right to keep and bear arms. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundy Awards. Top male influencer in the Second Amendment space is one category, and the other category is top voices of the Second Amendment. I am proud to be a finalist in both categories. Thank you for your support. All right, folks, so we're going to have to get a little geeky here. Just as a reminder, the Supreme Court in Nysurpa versus Bruin in 2022, following up on Heller in 2008, said the way you interpret the Second Amendment is you start with the text of the Second Amendment, which we've talked about before, the right of the people to keep and bear arms shall not be infringed. And then once a modern-day gun control law touches fingers with or is implicated by the text of the Second Amendment, the burden shifts to the government. Specifically, the presumption is that that modern-day gun control law is unconstitutional. And the only way that gun control law today can be saved is if the government can come forth and justify that law using history. History, specifically a type of history, i.e. a set of well-established, representative gun control laws at the time of the founding to show that the founding fathers would have approved of today's modern-day gun control law as being consistent with the right of the people to keep and bear arms in the Second Amendment. This is a high burden for the government to establish. And I want to talk about some of the myths that you see arguing over the role of history. It's very important that you understand this. It's going to get a little geeky, but I think it's going to be worth it at the end. To begin with, as a reminder, as we've gone over before, the first thing is the anti-gunners have to come forth with an actual law on the books at the time of the founding. These are actual laws that were enforceable, the rule of law, not just airy-fairy history by historians that want to make stuff up and say things like, of course the founding fathers would have approved that gun control law, or of course the founding fathers would support banning AR-15s if they were aware of them, that sort of thing. No, that sort of airy-fairy storytelling about what the founding fathers would have done or did not do or wanted to do, not relevant. The first step is that the anti-gunners, or those that want to come forth to justify modern-day gun control laws, must come forth with actual laws on the book that were enforced at the time of the founding. Those laws could potentially be the federal constitution, it could be state constitutions, it could be actual statutes on the book, or it could be common law that was embraced by American judges in the United States during the founding. Those are actual laws that were on the books that were enforceable against early Americans. Absent that, if the anti-gunners or the gun control movement cannot find actual laws on the books at the time of the founding, they lose. They lose. Now, with that said, you will sometimes, and this is what I want to focus on today, there are sometimes references you will see by the anti-gun movement and by the Biden administration's Department of Justice that says something along the lines of history is really important, history is really important. Then they trot out some historians to say all sorts of things about how the founding fathers really supported gun control laws. That's right, the same founding fathers that embraced the right of the people to keep and bear arms shall not be infringed allegedly would have supported all sorts of gun control laws even though they thought it was a fundamental constitutional right. Obviously, that doesn't make any sense, but you will see a lot of these arguments by the anti-gun movement saying that history is on their side and that the founding fathers were really into gun control. That is obviously absurd, but still we have to do the historical analysis. So I want to talk about how history can play a role, how history can be relevant, even if the history is not actual historical laws. I just want to give you a real-world example, and then I want to give you a couple hypothetical examples for you to reflect on, and then we can talk about this further in the comments below. Specifically, the actual example I want to give you is something we've talked about before, and that, of course, is the attempt by the anti-gun movement in America to justify magazine limitations, i.e. the number of rounds that are in a magazine for a semi-automatic firearm, by arguing that at the time of the founding in the 18th century, there were restrictions on the amount of black powder you could have in the home. We've talked about this before, as did the U.S. Supreme Court talk about this before in the Heller case in 2008. As you know, the reason why there were restrictions on having mass quantities, you could have black powder in your homes, just not mass quantities of it, is because at the time of the founding, all the cities were made out of wood, and if you had a conflagration or fire like you had in the Fire of London, you could potentially burn down the entire city. So the concern, or the why the black powder restrictions existed at the time of the founding, had nothing to do with crime control or restricting access to firearms or ammunition to criminals. It had everything to do with fire. And thus, those black powder restrictions at the time of the founding are not a historical analog law, or they're not historical analog laws that can be used to justify modern-day gun control laws today, because the why the law was enacted was different than the why the gun control laws are enacted today. And that's why those black powder laws at the time of the founding are not analogous and cannot be used to justify modern-day gun control laws. And how, for example, are we able to figure this out? Well, obviously, you have the laws in the book that specifically restrict the amount of black powder, but then certainly if you go back and you look at the history, articles at the time, books at the time, legislative history, whatever it is, talking about why these laws were enacted and the concerns about why they were enacted, that kind of general history could be relevant to tell us why the law was enacted. So that's a real-world example. Now let me give you two more abstract things, hypothetical examples that I've used in an article on corpus linguistics. Now we're not going to talk about corpus linguistics here today, but I will put a link to the article down below, and we will talk about a couple examples that came up in this, because I think the two hypotheticals I'm about to give you do illustrate the point of how historical context, history associated with the historical context of why a law was enacted at the time of the founding, or whenever it was enacted, could conceivably be relevant. Again, the anti-gunners still have to come forth with actual laws in the books, but sometimes the history behind those laws could be relevant. And here's an example. Let us say hypothetically, and again, you can get the details in this article in the Drake Law Review, which I'll put a link to down below. Let us say hypothetically, there's a situation where your grandfather said, "Stay off the grass." Stay off the grass. Grandpa says, "Stay off the grass." Now the question is, what does Grandpa mean? Let us assume for the sake of argument that's a law. Well, is Grandpa telling you don't use pot, don't use marijuana? Is that what he means by saying stay off the grass? Or is what Grandpa's saying don't screw up his landscaping by staying off his grass in the front yard of his home? Well, again, the statement is stay off the grass by Grandpa. Let us assume, and this is something discussed in a hypothetical discussion in my article in the Drake Law Review, let us assume that you found out that Grandpa was a drug addict in the 1970s and was very concerned about people using marijuana, and thus, as a consequence, was always telling people to not use marijuana, to not get involved with drugs, to not use pot. And therefore, when Grandpa says to you, stay off the grass, now that you know that his personal history, that historical context, well, that might lend credence to the why Grandpa is saying stay off the grass has to do with don't use pot, don't use marijuana. It has nothing to do with getting on or staying off his front lawn. That would be an example where the history, i.e. Grandpa's historical personal experience, might help us understand the purpose of his statement, stay off the grass. Now, there's another example dealing with, let's just say, and this is a hypothetical, guns at a bank. And again, this is also discussed here in the context of a hypothetical that William Baud, a professor at the University of Chicago, has used before. Basically, the idea goes like this. Let us assume, for the sake of argument, there is a law on the books that says the following: thou shalt not have guns at the bank. Thou shalt not carry guns at the bank. Let us assume that's the law. Well, somebody comes out and says, well, obviously that means you can't bring guns to a financial institution, because if you study what the word bank means, most of the time it comes up in the context of financial institutions, i.e. a bank where you keep your money. But then it turns out, let us assume that we then look at the historical record and we try to understand why was that law that says you can't have guns at the bank, and why was it enacted? Since the statement was you can't have guns at the bank, and it turns out that the legislative history, the historical context as to why that law was enacted was there was concerns about criminals and guns being used at the riverbank. Well, it turns out that the context and the why of that law had nothing to do with financial institutions and everything to do with, indeed, river banks. So again, obviously we can set aside the sensitive places illegality and unconstitutionality of such a hypothetical law, but we're dealing with hypotheticals to illustrate points, so we don't have to worry about that right now. But again, it's another example where the historical context of the why that law that says you can't have a gun at the bank, in that context would have explained that they are talking about the river bank because the people enacting the law were worried about robberies and violence at the riverbank having nothing to do with financial institutions. So at the end of the day, I'm bringing this up as an illustration of how history can sometimes play a role in helping us better understand perhaps why some of these laws were enacted and how they were enforced. But again, at the end of the day, we must never forget the critical footnote number 11 in Nysiper versus Bruin that says that whenever you're doing this kind of historical work, if there is any doubt or reasonable question as to what the historical record teaches us as to whether or not the government can justify the modern-day gun control law, the presumption is that the government loses and that the unqualified command of the Second Amendment, thou shalt not be infringed, prevails. And again, the critical part of footnote 11 says this. Again, because the Second Amendment's bare text covers petitioners, meaning the plaintiffs, Second Amendment plaintiffs, public carry, the respondents here, the state of New York, shoulder the burden of demonstrating that New York's proper cause requirement is consistent with the Second Amendment's text and historical scope. And this is the key language, folks. Quote, to the extent there are multiple plausible interpretations of Sir John Knight's case, which was the historical fight at the time in Bruin, to the extent there are multiple plausible interpretations of Sir John Knight's case, we, the Supreme Court, will favor the one, i.e. the interpretation. We will favor the one interpretation that is more consistent with the Second Amendment's command, period, close quote, which means that if there's any doubt about what the historical record teaches us, the government loses, freedom prevails, and the unqualified command of the Second Amendment shall not be infringed prevails and wins the day. Okay, folks. Well, I know this is a little bit more abstract and geeky. Let me know how you, if you like this and if you like more of these things. And again, don't forget to subscribe. Make sure you've subscribed. Some people get knocked off and have to resubscribe, so please do so and double check your subscription. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.